Welcome back to State and Local Government and Politics. My name is Jim Toot, and I'm an Associate Professor of Political Science at Central Virginia Community College. In Module 5, we'll discuss state constitutions. Part 1, Introduction and the Purpose of State Constitutions. While state constitutions do not receive much attention from academic researchers and are accorded only scant public attention, their importance does indeed merit our attention. The mere mention of the topic usually tends to arouse fears of boredom born of painful attention to legalistic hair-splitting among students of state and local government. In fact, state constitutions represent a topic of great importance, interesting historical developments, and clear contemporary relevance. State constitutions are also important to examine because they often mirror important political, economic, and social changes occurring over time. As states have moved from reflecting rural economies characterized principally by natural resource extraction in the 17th and 18th centuries to governing urbanized industrial economies in the 19th and 20th centuries to providing guidance to post-industrial and knowledge-based economies in the late 20th and early 21st centuries, citizens and their political representatives have made many revisions to their respective state constitutions and even replaced them in their entirety on a rare occasion. While there is debate taking place regarding just how adaptive state constitutions have been to changing times and situations, there is little disagreement that constitutions are important documents that set the context and specify the procedures for political processes wherein governors, legislatures, courts, interest groups, local governments, citizens, and others seek to influence the course of public policy. A constitution is often defined as the whole body of rules, written and unwritten, legal and extra-legal, which describe a government and its operation. The use of constitutions in states mirrors the development of what we call constitutional democracy at our national level of government. At its most basic level, the concept reflects the belief that government can and should be legally limited in its powers, and that its rightful exercise of authority depends on observing these limitations. A constitutional democracy is a system of government functioning with the belief that government can and should be legally limited in its powers, and that its rightful exercise of authority depends on observing these limitations. While most constitutions in the world, including that of the United States, are codified as single written documents, the notion of constitutionalism can also include multiple written documents and even some unwritten rules and procedures. In the case of Great Britain, for example, there are various written components of the Constitution, such as the Magna Carta from 1215 AD, and numerous statutes enacted by Parliament. But there are also some unwritten components, including principles derived from common law and royal prerogative. We can trace the development of constitutionalism back to 500 to 600 BC in ancient Greece, where some city-states had partially written or customary constitutions that were organized, according to Greek philosopher Aristotle, into either good or bad form of the rule of one, kingship versus tyranny, and the rule of few, aristocracy versus oligarchy, and the rule of many, polity versus mob rule. Constitutionalism in the United States was influenced by various sources, including developments in common law in Great Britain, as well as known writings of Enlightenment thinkers such as Jean-Jacques Rousseau and John Locke. While the U.S. Constitution is often considered the oldest written constitutional document still in use in the world, several American state constitutions are even older than the U.S. Constitution, stemming from the original charters of the 13 colonies. The Constitution of the Commonwealth of Massachusetts is quite likely the oldest written constitutional document still in use. It dates to 1780. The Fundamental Orders of Connecticut was considered the first written quasi-constitutional document of its kind in the world, dating from 1638. 11 other American states' first constitutions precede the U.S. Constitution of 1787 by at least a decade, illustrating that the concept of constitutionalism was well instilled at the state level well before the creation of our current national government. The main purpose of state constitutions are, within the limitations placed on them by the U.S. Constitution, to define the general purposes and ideals of the several states, including the determination of the common good of citizens, to establish republican and accountable forms of government with legal limits on the powers of government entities and their agencies, to provide a framework for governmental structures, including the scope of authority, mechanisms for exercising authority, and procedures for the passage and modification of state laws, local ordinances, and administrative rules and regulations. This framework includes the executive, legislative, and judicial branches of state and local government. To provide for an independent judiciary that allows citizens to seek court-ordered remedies for illegal actions of the government, as well as a process to change laws they believe to be unconstitutional. To provide legal definitions of key concepts, for example, citizenship, property rights, parental rights, and so forth, and prescribe a process for establishing basic political rights, such as standing for public office and voting. To establish and define the powers of local governments, including cities, counties, townships, and special purpose governments. To establish the requirements for holding elective and appointed office, as well as setting the terms of office for elected officials. To provide for a process of removal of incompetent and corrupt elected and appointed officials, which can include recall and impeachment. To define responsibilities for major government departments and agencies, and the principal duties of individuals heading up those state and local government entities. To establish a system of taxation and budgetary process. To provide for the public safety of the citizenry, including regulatory authority for civil and criminal actions to be exercised to promote public health and safety, and to operate effective civil and criminal justice systems. To provide for a process of replacing or revising the state constitution. Depending on the state, these processes can include initiatives, referenda, constitutional conventions, and legislative action, and to establish the rights of citizens, including both negative and positive rights and freedoms. Negative freedoms are often called civil liberties, which include freedom of speech and assembly, among other rights. Civil liberties are individual or group protections from a potentially oppressive government. Positive rights, on the other hand, are things government can do for citizens, including the provision of education, economic assistance in times of need, timely assistance in times of natural disasters, and the preservation of cultural assets with public libraries and museums. In Part 2, we'll discuss the content of state constitutions.